I have been wondering for some time whether Trump's attorneys are actually dumb or if they just have like an impossible case to represent. And so they can't help but look dumb because they're told, to what do they call it? To defend an untenable case. It's a tough one because they really do have really impossible expectations set forth by Donald Trump. On the other hand, Donald Trump has basically guaranteed that serious lawyers don't want him as a client because he doesn't pay, number one. And number two, he keeps asking him to do illegal stuff with him. And he keeps literally dragging them into criminal court. That's a problem. Serious lawyers don't want that. But on the other hand, former president, hey, there's a chance he'll make history. So the question was, are Trump's lawyers truly idiots? It turns out the answer is yes. Here's Midas Touch.
This is Michael Popak, Legal AF. Well, the old theme song from Sopranos is playing in Joe Tacopina's mind. I woke up this morning. Joe Tacopina woke up this morning and he filed a motion for mistrial in the E. Jean Carroll case. He's not even done with the cross-examination of E. Jean Carroll, but he's so getting his backside kicked by both E. Jean Carroll and the judge that he did something extraordinary. It's not even mid-case. He's not even, it's 1/3 of the case through and he thinks he's got a grounds for mistrial, which he doesn't. So let me start with the fresh news. The judge already denied the motion for mistrial. Done. Move.
Remarkably quickly, by the way. Remarkably quickly. I also do want to say I've been busting Michael Popak's balls pretty significantly. And I did want to play this because I feel like I want to show and not just give lip service to the fact that I think Michael Popak is a great legal analyst, a great communicator about these things, but actually show him doing it. This is a fantastic breakdown of one of the silliest things I have ever seen a professional put their name to. Here it is.
Vaughn, cross-examine the witness. She's your witness, Mr. Tacopina. Finish with E. Jean Carroll. But let me tell you how we got there and why this shows complete weakness and a self-awareness, I guess, that he doesn't completely understand by Joe Tacopina's point, that he's conceding that they're losing. Let's start with this as a trial lawyer. No perfect trial. There's no such thing as a perfect trial. You're not guaranteed by the U.S. Constitution a perfect trial. You're guaranteed a fair trial. And that's what the judge has been giving him. He just doesn't like the Tacopina Habba side and Trump side, just don't like that they're on the losing end of ridiculous motions that have no support in the law at all. All we've learned so far at this point in the trial and in the motion that was just filed at 5:01 this morning is that Joe Tacopina doesn't have a command of the English language, of grammar, of syntax, and of English literature. Because most of what he's arguing about, if you have to believe that what you put in your motion first is most important to you, then what's most important to him is that Joe Tacopina can't ask a proper question in a federal courthouse and
just give it a moment. I'm telling you, every moment of this leading up to the revelation is worth it. I thought Popak was being a little bit snooty talking about English literature, but no. He's dead on. This is an amazing piece of rake stepping.
Get an answer back without having the other side properly object and the judge sustain the objection. That's not on them. That's on you. Yes, this is an adversarial process. Everybody has a role. The judge is the umpire and calls the balls and strikes. The other side gets to object. And then the objection is either sustained or overruled. And then you move on. See, Joe Tacopina normally plies his trade, if you want to call it that, in a state courthouse, doing criminal law, where there's a lot more leeway, especially in New York State. I've been in New York State Supreme Court, a lot more leeway than in federal court. Federal court, you better mind your P's and Q's. You better dot your I's and cross your T's. You better know your federal rules of civil procedure. You better know your federal rules of evidence. If you don't know them, the other side's going to remind you what you're missing. and you got to figure out from the judge how to make objections. Some objections the judge is okay with what's called a speaking objection. Sometimes it's you got to put the smallest amount of words on the record so that the jury doesn't really know what's going on. Some judges require you to cite by the rule number 403, 401, 412, and then makes decisions based on that. But so the objections here are basically that Joe Tacopina, because he can't ask a proper question, keeps getting slapped down. Then he gets frustrated because he can't figure out how to ask the proper question, and he blames the judge. I'll give you an example. If you ask a question of a witness like Joe Tacopina has been doing, you can bring out the following under question and answer. Your position, Miss Carroll, is that you and Donald Trump were in a dressing room about 8 foot but 12 feet wide at about 6 or 7 o'clock at night on a Thursday night. Is that right, ma'am? Yes. And that during that time, you say at some point you were pushed up against the wall, right? Right. And that you injured your head. Yes. And that at some point my client sexually attacked you. Isn't that right, ma'am? Right. But nowhere. Your claim to the jury is there was no one around you. There were no other people there. There were no other salespeople. There were no security guards. Nothing. Right, ma'am? Right.
Again, so that is how he was supposed to ask these questions. Now listen to how he did.
Okay, that's a proper cross-examination. What you can't do is what's called argumentative questioning, which is sort of what it sounds like. It's not that you're arguing with the witness. It's that you're doing your closing argument. You as the lawyer are making statements that are just for argument's sake for the jury, not really to properly ask a question to the fact witness. So you would say, so you want this jury to believe that there are not a soul around, not a person around at a very busy department store that prides itself at having service.
So I'm just stressing here, that's Joe Tacopina, Trump's lawyer, not understanding what he is supposed to be doing, like what his job is, how that's supposed to look. That is hugely embarrassing. I did not jump on this Tacopina's an idiot train when he was doing the various interviews, yada, 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 on TV. Thank God for just the sake of, I don't know, dignity around the world, the collective embarrassment not radiating through the planet, that he's not doing those anymore. But he it's obvious now he does not understand what his job is supposed to be, like what a lawyer is supposed to be doing in that position. And obviously he's better than Haba because he's talking instead of her. Jesus Christ. I assure you it gets worse. It gets, in fact, hilariously worse in about 30 seconds.
Prides itself. Objection. Argumentative. Where is your question, Joe? That's an argument. And then when you get shot down because you're asking argumentative questions, and it happens to me, happens to other people on Legal AF that are practicing lawyers, you just regroup. You try to get away with it. It didn't work. So you say, let me rephrase. And then you rephrase. So your position is that no one was around on 5 o'clock in the evening in the lingerie section of Bergdorf Goodman. Right, ma'am? That's it. And you move on. And then you make your argument, the actual argument in closing time, like 5 or 6 days from now. You say, you can't believe that, and then whatever argument you want to make.
That's what you do, for the record, if you know what you're supposed to be doing, if you know when you're supposed to do that. If you don't, apparently, like Joe Tacopina, you just blunder through. But it gets worse because now he goes into, and let's jump ahead a little bit. Now he goes into something that you don't need any education at all to understand. All you need is an understanding of the context in which you asked a question. Here it is.
Top of it, your second big argument, assuming that your arguments in your motion match what you think is the most important, is you don't understand English literature. You wanted to make a big deal, Joe Tacopina, in front of E. Jean Carroll and the jury, that she had in her memoir a chapter or a section about her plan to send all men to Montana for retraining. That in the literary business is called satire. You learned that, I think, in 7th grade. She didn't really mean that. But just like The Handmaid's Tale by Margaret Atwood is satire, and there's a legitimate political and other discourse in society by having satirists. That's satire. Why you wanted to continue to bring that up? What you wanted to show that she's nutty, she's kooky, she's off her rocker because that was her plan. You didn't get it with satire. If you didn't get it, the judge got it, because the judge said, as you continue to drill down on this ridiculous line of questioning, the judge sort of stopped it in its tracks so we can get to real evidence in the case, and said, she said it was satire, like Jonathan Swift's A Modest Proposal from 600 years ago, right, ma'am? And she said yes, and the judge said, move on, it's satire.
Let's pretend for a moment that you don't know what A Modest Proposal is. You've never heard of this particular document, this pamphlet written by Joseph Smith. It wasn't 600 years ago, but still. Let's just say you don't know what that is. Fine. That's fine. But you would assume that the judge does know what it is because they mentioned it. Right? And you would assume that the judge has an understanding. So again, it doesn't require that Joe Tacopina know what this document is. And as we're going to find out, he doesn't. He draws the wrong conclusions, folks. And unfortunately, he doesn't have the ability to realize that he doesn't understand the document because his brain isn't wired correctly.
You really mean it?
Let's take a quick break to talk about our next part.
Jordy got me. Oh. I was looking for that like a hawk. All right. Yeah, I got to get to this. I literally was trying to catch my breath laughing. Here we go.
And then Joe went home and looked it up. Or his trial team looked up A Modest Proposal. Again, I think you read about A Modest Proposal in 7th or 8th grade. Maybe it's 9th grade. And A Modest Proposal, Jonathan Swift wrote a whole satire about solving the Irish poverty problem by eating Irish children. And so he doubled down, Tacopina, in his motion, and he writes in the moving papers, Judge, I read A Modest Proposal now. Like now, he just got around to it. And it was 300 years ago. And that was about Irish poverty and Irish cannibalism. This was about sending all men to Montana for retraining. I don't see the link. Really, Joe? You don't see how that's analogous in the world of satire?
Okay. Look. I'm not saying that you have to know what A Modest Proposal is. I'm just saying if you Google, like I assume Joe Tacopina did, if you Google A Modest Proposal, like the first entry that will come up, like Google the word satire, A Modest Proposal. That's what the judge was talking about. Like the first entry that comes up is how a modest proposal is like the standard example used when talking about satire. What is satire? I don't know where he was going with the Handmaid's Tale thing. Satire is basically like a sarcastically written document. How about that? It is putting forward in A Modest Proposal the idea that to solve this Irish famine that was going on at the time, the Irish should just eat their own kids. And of course, it wasn't to be taken literally. It was as if to say we're being so cruel to the Irish right now, so callous to their suffering, that this is the sort of thing we're putting forward. You don't need to understand all that. All you need to understand is that it's satire. And if you don't know what satire is, okay, you got to look that up. But to then come back to the judge and say, oh, wait a minute. A Modest Proposal has nothing to do with this. It's about Irish kids and cannibalism. He's just demonstrated that he literally doesn't understand the concept of satire. I don't know how he's ever going to be taken seriously anywhere ever again. Like, literally, I don't see how anyone can look at this person and say, yeah, I can trust them with my serious business. I mean, it would be difficult to overstate how dumb you have to be to get told by a judge that the person you are questioning in court is using satire like example X, and then you go look up example X and not what the definition of satire is, and come back at the judge with a, I don't know, book report from a kid that didn't read the material.
And that's your grounds for mistrial? And then, so he didn't like that. That's unfair and prejudicial, the whole satire thing. And then he doesn't like the fact that the judge isn't letting him vigorously cross-examine her, and outside the presence of the jury, threatened to go after Eric Trump because Eric and Donald Trump were busy social media posting about things they shouldn't be talking about to try to influence the jury, which is a crime. And they didn't like the fact the judge warned them after it came to his attention that even though Donald Trump is too busy to show up at trial, a fact that is not lost on the jury. Let me repeat, juries hate when parties don't show up for trial, especially one this important on these facts. So the jury.
Going to answer some questions from the wicked audience, because I think these are good if you're not familiar with them. And I'll do a more dignified face for Popok there. In fact, you know what? Let's just make this Q&A time. Why not? We'll have some fun with this. I really wanted to make fun of Takapina there above all else. So look, let me just put a cap on the Takapina talk. Guy's a knucklehead. I'm shocked to my core that Trump can't just get like a normal, like a regular lawyer to represent him. There are so many lawyers in the United States of America. How on earth can Trump not get just somebody of average competence? From what we've seen of Trump's lawyers getting wrapped up in legal mayhem, be it telling the federal government that they'd handed back all the documents when they didn't, working out deals with fake electors on Trump's behalf when that is straight up treason. I guess it shouldn't surprise me, and yet it does. What can you do about this? Just maintain in your head a sense of who the villains are and how unserious they are about the truth. The fact that Takapina's out there trying to get this whole case thrown out because he doesn't understand what satire is should tell you a lot about what the opposition to decency is all about. They do not care about truth. They are just looking to make a stink. They only care about duping people, tricking people that will fall for a lot of noise and not listen to a lot of details. And they're hoping, they're making a gamble that enough people in America will refuse to have the courage to look at facts, to honestly assess things, that they can get away with these crimes. That's a shame. We'll find out if they're correct. But the neat thing is, in a court of law, facts still matter. And now Trump's business has been brought in front of a court of law. It has been in New York. It has been with E. Jean Carroll and Alvin Bragg, and it will continue. It's going to happen in Georgia. And hey, let's hope that the Attorney General finds his spine, because it might just happen at the federal level as well. All right, let's address some questions I saw from the Wicked community.